Senator McDougall.
I'll ask Hurley. I just want to intervene to mention that while I was temporarily out of the chamber, the Minister took it on himself to say that I was dismissive of Mr Justice Gerard Hogan. I'm not dismissive of him at all. He's a good friend and a jurist who I admire greatly. I am, however, dismissive of the suggestion that Ireland can unilaterally and without making a protocol or reservation or of any kind in acceding to the CETA agreement, reserve unto itself in safety the right to refuse to implement awards of the arbitral courts on the grounds that they conflict with the Irish constitutional order. And I say that, and I repeat that I say that, why I say that, if somebody came to the courts in Ireland and was confronted by a defence by the Irish government that to implement the agreement would contravene the Irish constitutional order, the dissatisfied Canadian or whoever else it may be under some future agreement investor could ask the Irish court to ask the European Court of Justice to rule as to whether Ireland's refusal to implement the award was consistent with the law of the European Union, and on that matter, I favour hugely the view taken by Mr Justice Charlton rather than the view taken by the majority in the Supreme Court. And I want to make one final point. The Minister on the last occasion correctly said that one judge, to wit the Chief Justice, who was in the minority, had responded to some of Mr Justice Charlton's points. He had, but in respect of many of them, he did not. And he effectively dismissed, if I may use that phrase, the views of Mr Justice Charlton in a laconic way. But what I'm saying is that if this matter ever comes before an Irish court, and if it ever gets to the Court of Justice of the European Union to rule as to whether Ireland's refusal to implement the award of an arbitral court under the CETA agreement or any other agreement on constitutional grounds, which has become binding as a matter of European law, the European Court of Justice will have jurisdiction to determine that issue if it's asked by an unhappy investor. And as I said on the last occasion, I would put my life savings on the proposition that they will say that Ireland will not, cannot do that. And I say that because the Vienna Convention, the Washington Convention, all of these things make it quite clear that where a treaty or international agreement is adhered to by a member state, if you want an opt-out in terms of your domestic law, that has to be signalled to everybody so that everybody else who's party to the agreement knows that that is the situation. I want also to make the point that the Attorney General, when confronted with the interaction of CETA with Section 10 of the with its 2010 Act, said the following in his submission to the court: because nothing prevents the Oireachtas from amending or even repealing the 2010 Act if it wished, the interaction of CETA with the 2010 Act cannot credibly be suggested to constitutionally diminish sovereignty. And that was the position of the Attorney General in the court when he made his submission. And the court took a different view. And now we have the Attorney General effectively advising, if the Minister's description of his advice is correct, that we have the Attorney General saying that this does give us, this makes everything constitutional, that we are amending the Arbitration Act to accommodate this. Now, all I'm saying is we may think that in relation to domestic enforcement, but in the end, the European Court of Justice will have the final say, and I cannot believe that they would uphold a unilateral provision which, in the words of the Attorney General, can be amended or repealed at the wish of the Oireachtas, that changes Ireland's obligations under the statute. So I finally conclude by saying this, Alaska, we shouldn't ratify CETA. Other states are not ratifying CETA, and we should not do so for one very solid reason. Every Canadian investor should have total confidence in the Irish legal order to uphold his or her rights in Ireland. That may not be true of in terms of confidence, of all of the member states in the European Union, but it is true about Ireland. We have a comparative advantage in that our legal system is totally trusted by outside investors. The experience since the provisional entry into force of CETA has shown that this issue of whether Ireland should or should not be bound by the arbitral courts has in no way inhibited Canadian-Irish trade or investment. And I make the last point, and it is an ideological point. We are elevating international capital to an equivalent position on the plinth of international law with private investors' interests. And we are on the one hand, and with states' capacity to govern their own jurisdictions in a democratic manner on the other hand. International capital has no such rights. It doesn't have those rights. It shouldn't be accorded those rights. In the last analysis, every member state of the European Union and every member of the United Nations must, in the last analysis, do its utmost to preserve its own capacity to fend off challenges or threaten challenges from international capital when it does conflict with the sovereign independence of the institutions of that state. I finish by saying this: CETA is unnecessary insofar as it is not yet in operation. The arbitral system envisaged by CETA is unnecessary, and it's a precedent which the Department of Foreign Affairs should in future avoid and say, Ireland does not need these provisions. We are not signing up to these type of provisions which are in effect elevating international capital to the status or co-equal status with sovereign states. That is not in the Irish interest or the people's interest, and it's not ultimately consistent with the spirit of our Constitution. Thank you.